A very good evening to all of you friends. On behalf of the entire team at Gradeup, I welcome each and every one of you for today's live session that we are conducting in our YouTube channel. A very good evening to all of you. So friends, we are back with another very interesting session on important legal affairs. A daily show that brings to you the most important legal news coming across India. These newses are absolutely essential for each and every one who is preparing not only for CLAT but also for other law entrance examination like ALET, Symbiosis, MHCET and other examination. So a very good evening to all of you. I believe that you guys are doing absolutely fantastic, keeping in mind the kind of things that is happening across the world. We are just getting over, or rather in the process of getting over with the second wave of this pandemic. So a very warm welcome to all of you. So friends, today I am going to discuss with you a very important and a landmark decision that has been rendered by the Supreme Court today. And that decision that I'm going to talk about is a very interesting one. It deals with the law of sedition. Today, the Honorable Supreme Court of India has discharged journalist Vinod Dua in a sedition case. A sedition case was filed against journalist Vinod Dua, wherein he was being little critical about the government over the handling of COVID-19. Today, the Honorable Supreme Court of India held that journalists do also have the freedom of speech, and criticizing a government does not mean sedition. We all as individuals have a right under the Constitution to criticize the government. Now, if a journalist tomorrow is criticizing the government and the government does not want any criticism, very well, no government wants criticism, but does it mean that a case of sedition be leveled against that particular individual? So today basically we are going to talk about this landmark judgment that has been rendered by the Honorable Supreme Court of India. But before that, some very important notification from Gradeup. Gradeup brings to you on 5th of June, as you know, we will be celebrating Environment Day. So do join the contest that we are having on the 5th of June celebrating Environment Day. Follow us on the Instagram. The link is given in the description box below. Follow and upload a photo or something, a poster or a poem relating to Environment Day. Lucky winners will be announced. Gradeup brings to you on 5th of June in conversation with Tariq Khan at 7 p.m. on our YouTube channel. Gradeup brings to you a booster crash course for CLAT 2021 aspirants. Since CLAT will happen and it is not like your CBSE boards or your ICSE boards that has been cancelled. If you are preparing for CLAT 2021, get yourself enrolled for the booster crash course. Gradeup also brings to you a comprehensive course for CLAT 2022 aspirants. The batches have already started from the 1st of this month. Gradeup also brings to you a very, very important course called a new course on mock test analysis. Now, understanding things is one thing and how to solve a particular question is another thing. CLAT, ALIT, Symbiosis and other host of examination is going to test you by asking question. So know how to solve a question. Gradeup also brings to you a crash course for BHU, BLET, Jamia, LLB 2021. So those of you who are interested in sitting for Jamia, Banaras Hindu University, get enrolled to this particular crash course. Gradeup also brings to you a comprehensive course along with foundation module for CLAT 2023 aspirants. So those of you who are preparing for CLAT 2023, here is your chance of getting yourself enrolled for CLAT 2023 comprehensive course. So how do you attend these classes or get yourself enrolled to these courses? All that you need to do is to get your Gradeup Super subscription. Once you get your Gradeup Super subscription, you can attend these classes that are taught by expert faculties across India. You can opt for a 3+1 month course meant for CLAT 2021, a 14-month course meant for CLAT 2022, and a 24-month course meant for CLAT 2023. So we have Gradeup Super subscription available for CLAT 2021, 2022 and 2023 up in Gradeup. So get yourself enrolled to these beautiful courses which I had told you by subscribing to Gradeup Super. So let's start with today's class. In today's class, we are going to talk about a very, very important and a landmark judgment of the Supreme Court of India. Journalist Vinod Dua was critical about the government's handling of this pandemic. In his show, which is available in YouTube, called the Vinod Dua Show, he made certain comments which were very, very critical about the government of the day. So, a person, an MLA of the Bharatiya Janata Party, had filed an FIR under sedition against Vinod Dua. Today, the Supreme Court of India has clarified that every journalist is entitled to the protection in terms of Kedarnath Singh. Now, what is Kedarnath Singh? That's a landmark judgment, a 5-judge bench judgment of the Supreme Court of India dealing with sedition. So the prosecution under section 124A of the Indian Penal Code must be in accordance with what has been laid down by the Constitution bench judgment in Kedarnath Singh. The scope and ambit of sedition law, I repeat, the scope and ambit of sedition law has been properly explained by the Honorable Supreme Court of India in the Constitution bench judgment of Kedarnath Singh. Now, I'm going to clarify what is sedition. Now, sedition was a law that was made by the Britishers. Why did the Britishers make such a law? To suppress freedom struggle. To suppress freedom struggle, this law was enacted. Now, freedom fighters like Bal Gangadhar Tilak, Mahatma Gandhi were all prosecuted under sedition law. The first Prime Minister of India, Pandit Jawaharlal Nehru, had said that the sooner we get rid of the law, the better it is. But successive governments came into power and the law till date remains in the law text. So what exactly is sedition? If a person by his words, by his action, makes any comment whereby he is creating dissatisfaction amongst the citizen against the government, that is what is sedition. So, if tomorrow someone is critical about a particular policy which the government of the day has made, then that person can be prosecuted for sedition. Now, sedition is a very, very important law. Now, on one hand, there is this law of sedition which very categorically states that if a person makes any statement wherein he is creating dissatisfaction amongst the citizen against the government, then he can be punished for a period of 3 years till life imprisonment. Now, the punishment under the Indian Penal Code for sedition is 3 years up to life imprisonment. So, there is a wide punishment available and the discretion is given to the courts as to how much of punishment is to be awarded. If I am not wrong, Mahatma Gandhi, the father of the nation, was given a sentence of 6 years of imprisonment. Freedom fighters like Bal Gangadhar Tilak were also booked under this particular law. So, all that I'm trying to say, that here is a particular law that was made by the British Raj to suppress freedom struggle. Am I clear? A law that was created to suppress freedom struggle. Now, in today's world, we as citizens do have certain freedoms, certain constitutional guarantees. As citizen, we have certain constitutional guarantees. Article 19 of the Indian Constitution deals with freedom of speech and expression. So on one hand, the Constitution guarantees freedom of speech and expression, and on the other hand, there is this criminal law which penalizes for sedition. You will be amazed to know that in England, the law has been repealed. From where did we get sedition law? From England. In England, this law very recently has been repealed, has been taken down from the books. Am I clear? So what does Kedarnath Singh and the law of sedition means? Law of sedition means any act within the meaning of section 124A which have the effect of subverting the government by bringing that government in contempt or hatred or creating dissatisfaction against it would be within the penal statute, because the feeling of disloyalty to the government established by law or enmity to its import the ideas of the tendency of public order by the use of actual violence or incitement of violence. So Kedarnath Singh says, if someone by his words, if someone makes a speech which has the tendency to cause violence or incitement to violence, if someone makes a speech which has the tendency to cause violence or cause incitement to violence, only then it can be a sedition. A citizen has a right to say or write whatever he likes about the government. Now, this is what Kedarnath Singh says. Kedarnath Singh says that a citizen has a right to say or write whatever he likes about the government, or what measure by way of criticism or comments, so long as he does not incite people to violence against the government established by law or with the intention of creating public disorder. So if a statement is made wherein there is a chance of creating public disorder, if someone makes a statement wherein something can be attributed to creating public disorder, that is called sedition. But if creating public disorder or inciting people to do violence is missing, it cannot be sedition. So today the Supreme Court has reiterated what has already been said in Kedarnath Singh. A person can be critical about the government. Haven't you seen the judges of the Supreme Court very recently dealing with pandemic issues, lack of oxygen, lack of vaccination, has made certain comments in the courts. They were being critical about the government. But does it mean it is sedition? The answer is no. The provision of section 41 read as a whole, along with the explanation, makes it clear. 41 is mistyped, okay, take this out. the provision of the section 124A of the Indian Penal Code read as a whole, along with the explanation, makes it reasonably clear that the section aims at rendering penal only such activities as would be intended to have a tendency to create disorder. So if a statement has the tendency to create disorder, disturbance to public peace by resorting to violence, only then can a statement be called seditious. Did you understand the law of sedition now, friends? Am I clear to all of you? So this was a judgment that was rendered by Justice Uday Lalit. He will become the Chief Justice of India after Justice Ramana retires. So Justice Uday Lalit said that Kedarnath Singh is the law unless and until there is an incitement to violence. There is a tendency to create public disorder or to create disturbance of public peace. It cannot be treated as sedition. Am I clear? Moving ahead to the next important news. The Delhi High Court has said that Mr. Gautam Gambhir and his foundation, the Gautam Gambhir Foundation, has violated the Drugs and the Cosmetic Acts, because there was a news that Gautam Gambhir Foundation was distributing essential medicines to combat COVID-19. So here was a gentleman who was doing something for the people, but he was also hoarding a lot of important life-saving drugs. Today, the Delhi High Court has said that Mr. Gautam Gambhir, who was distributing important life-saving drugs like Fabiflu, Remdesivir and others, should be liable for prosecution for selling these medicines. The Delhi High Court has said that you did charity, but you also caused a lot of impediments. You caused shortage to the society. The general patients who needed the medicines could not get it. That is what the Delhi High Court had to say about Gautam Gambhir's foundation, who was caught distributing important life-saving medicines during COVID-19 pandemic. Okay? Fantastic, fantastic. So friends, as usual, let us start solving some questions. Up on your screen is an MCQ. Please tell me what is the correct answer. The Constituent Assembly became a sovereign body when? When did the Constituent Assembly become a sovereign body? The day we got independence. The day we got independence. It was 15th of August, 1947. So on 15th of August, 1947, the Constituent Assembly became a sovereign body. Question number 2. The D.K. Basu versus State of West Bengal. The landmark judgment of D.K. Basu versus State of West Bengal deals with what? safeguards against sexual exploitation, safeguards against arrested person, safeguards against children, safeguards for unorganized workers. With which of the following issue DK Basu deals with? DK Basu is more or less like the Miranda warning in the US. Safeguards for arrested person. Safeguard for arrested person. Am I clear? Safeguard for arrested person. Very good. Some of you have given me wonderful answers. Great. So friends, if you are liking today's session, do press on the like button. If you are liking today's session, do press the like button. Okay. Question number 3 is up there on your screen. In which landmark judgment a police chief was held guilty of causing outrage to a modesty of a woman? I'm sure you guys know it. It is KPS Gill versus Rupan Diol Bajaj. Okay. Option B is the correct answer. KPS Gill versus Rupan Diol Bajaj. Question number 4. What does rule of law mean? What does rule of law mean? Does it mean all persons are equal in the eyes of law, or it means treating all unequals as equal, working according to law, or is it distributing state largesse to everyone in equal proportion? The correct answer is equality before the law. Everyone is equal before the law. Be that as it may, whether you are a rich man or a poor man, you are a Hindu, you are a Muslim, you are a Sikh, you are a Buddhist, you commit a crime, you will be subjected to the same law. So the rule of law, may you be how big, remember the law is bigger than you. May you be as tall, the law is taller than you. That is what is the meaning of rule of law. Okay, fantastic. Some good answers. Very good. Question number 5. Question number 5. Right to issue writ, that is given under the Constitution. So in case a citizen's fundamental right is violated, he can approach the High Court under 226 or the Supreme Court under 32 for the issuance of a writ. Now, issuance of a writ is which right? Is it right to equality, right to freedom, right to constitutional remedies, or is it right against exploitation? The correct answer is option C, right to constitutional remedies. Right to constitutional remedies. Moving on to question number 6. Who is the Chancellor of NLSIU Bangalore? Very important. Who happens to be the Chancellor of NLS Bangalore? National Law School of India, University, Bangalore, which is situated in Nagar Bhavi. This is one of the best law schools in the country. So let's see. Who is the Chancellor of NLS Bangalore? Let's see the correct answer, and the correct answer is the Chief Justice of India. The Chief Justice of India is the Chancellor of NLSIU Bangalore. So whoever becomes the Chief Justice of India as on today, it is Justice N.V. Ramana. Justice N.V. Ramana is the current Chancellor of NLSIU Bangalore. Am I clear? Question number 7. Which of the following bodies are entrusted with laying down rules relating to the standard of professional conduct and etiquettes for advocates in India? Is it the Supreme Court? Is it the Bar Association of India? Is it the Bar Council of India or the Delhi Bar Council? The correct answer is the Bar Council of India. The Bar Council of India is entrusted with the duty of laying down rules relating to the standard of professional conduct for an advocate. Am I clear? Have I made myself clear? All of you. Great, great. Question number 8. Who is the chairman of TDSAT? TDSAT means Telecom Dispute Settlement Appellate Authority. Is it Justice Shiva Kirti Singh? Is it Justice Uday Lalit? Is it Justice A.M. Khanvilkar? Is it Justice Rohinton Nariman? Justice Uday Lalit is a judge of the Supreme Court. Justice A.M. Khanvilkar is also a judge of the Supreme Court of India. Justice Rohinton Nariman is also a judge of the Supreme Court of India. So by elimination process, you can come to the right answer. Justice Shiva Kirti Singh. Justice S.K. Singh, a former judge of the Honorable Supreme Court of India, is the chairman of the Telecom Dispute Settlement Appellate Tribunal. Very recently, I think yesterday itself, the Supreme Court had directed that Justice Shiva Kirti Singh be given an extension insofar as being the chairman of TDSAT is concerned. Very good. So Justice Shiva Kirti Singh is the right answer. Moving on to question number 9. What does amicus curiae mean? What does amicus curiae mean? I'm sure that you guys are aware of it. It is the friend of a court. A court can appoint a lawyer to help the court in coming to a proper conclusion. Suppose a particular judge does not have any idea about intellectual property or data privacy. Now, data privacy was not a law. There was no concept of data privacy when a judge gave his law exam. Right? Right to privacy. Today we have right to data, your data. So if a judge is not aware of a particular law, he can ask a lawyer to be a friend of the court and help the judge and the court understand the nuances of a particular law. Right? So the correct answer is option B, friend of a court. So guys, if you're liking the session, do press on the like button, do subscribe to our YouTube channel, and do not forget to press the red icon, bell icon, okay? Question number 10 is up there on your screen. In law, the term neighbor means what? Does it mean people who might be affected by your action? Does it mean people who stay in your locality? Does it mean people who live adjoining to your residence? Or does it mean the word has not been given a particular definition? Which of the following is the correct answer? Please tell me. Some people are saying yes, it is A. Some people are saying B or C. Okay, fantastic. So people are confused in this particular question, right? So what I see is that some people are confused. So what does the word neighbor means? What does the word neighbor means under the law? The word neighbor means people who might be affected by your action. People who might be affected by your action is called a neighbor under law of tort. If you remember, negligence or nuisance. The best example would be nuisance. Suppose you are playing loud music in the middle of the night and your neighbor is unable to go off to sleep. That means people who might be affected by your action. The word neighbor means people who might be affected by your action. Am I clear? Have I made myself clear? Is that clear to all of you guys? So friends, somebody had asked me what is amicus curiae. Amicus curiae means a friend of a court. A person can be called by the court to help the court in coming to a proper conclusion. That is what we understand as amicus curiae. Is that clear? Okay, fantastic. Okay, fantastic. So friends, do like, do comment, do share and do subscribe to this beautiful YouTube channel. These classes are meant for students who are preparing not only for CLAT 2021 but also for CLAT 2022 and 2023. Do subscribe to Gradeup Super. Once you get your Gradeup Super subscription, you can avail all the classes that we are conducting in our Gradeup Super app. Friends, if you have any queries or any doubts, you can WhatsApp us on our official WhatsApp number, which happens to be 93544 99530. For any course related query, you can call us at 96500 52904 as well as 93195 99244. With this, we come to the end of today's class. Thank you very, very much. Stay home, stay safe, stay healthy. God bless you. Bye-bye. Good night. See you tomorrow again at 8 o'clock with your favorite daily legal affairs series. Thank you. God bless you.